3. Welcome back to PubK's annual review webcast. We hope you're enjoying the most convenient way to hear expert briefings on the year's most important legal developments impacting government contractors. My name is Robert Nichols. I'm a partner with Nichols Lew and the moderator of the second panel today on claims, disputes, and terminations. My colleagues on this panel are Craig Holman from Arnold & Porter, Ann Perry from Shepard Mullen, and Jerry Summers from the Civilian Board of Contract Appeals. Judge Summers, thank you for joining us today. Let's get started. We're going to turn right to Ann to start with two cases, starting with the ECC CENTCOM case. Ann?
Okay. So ECC CENTCOM deals with a construction contract in which ECC was awarded a $40 million design and build contract for 2 facilities for the government. It was supposed to complete performance in 710 days after the notice to proceed, but right before the 710 days had elapsed, the contracting officer said, "You're late, what are you going to do?" ECC didn't respond. 2 weeks later, after performance was to be completed, the government issued a show cause notice to ECC because of the delayed performance and asked for a realistic and reasonable schedule for completion. ECC responded, admitting it was delayed and that at that point it was only 52% done, but claimed it had suffered all sorts of mobilization delays, manpower shortages, material delays, changes, weather, etc. But it didn't seek in this response a final decision from the contracting officer, and it didn't certify this as a claim or even a request for equitable adjustment. The contracting officer thereafter terminated ECC's contract for default due to the delays. In the litigation, ECC defended itself from the termination for default, arguing that it had excusable delays and therefore it wasn't responsible for it shouldn't have been terminated for default. Unfortunately, ECC throughout the entire dispute process had only ever submitted a series of letters to the contracting officer, never certified them, never asked for a final decision, did say that some of these were requests for equitable adjustment, but also stated that it was intending to submit a claim. Unfortunately, it never did submit a claim. Rather, it just had these series of letters, never certifying. So ECC argued that the letters, when you looked at them as a whole, looked like a certified claim, even though we didn't certify it close enough. But the board said no, that in fact, if you're going to have a certified claim, you have to actually ask for a final decision, you have to have a sum certain, because clearly you're asking for money or at least a specified period of time, and you never did any of that. So the moral for that story, because of course their defense was dismissed, is that for excusable delays, you should always submit certified claims. And that's probably true across the board. If you think the government's going to raise a claim and you think you have a legitimate defense, if you are not sure whether or not it's something that would require a certified claim, you should submit one to protect yourself, right? So contracting officer denies it, at least you have jurisdiction to defend yourself.
So Ed, do you read this case as saying that contractors now have to submit certified claims for any defenses they may have to a default termination?
So interestingly, 2 things. It's not just contractors, so the government can get dinged on this as well, right? So the government has to assert a claim, sometimes to raise its arguments in court as well. There are some that don't. For example, the government, which we've seen quite frequently now in response to a claim, argues that there's fraud, and therefore the claim's excused because of fraud. That doesn't require a prior contracting officer decision. And the other is a prior material breach. So if your argument, your defense is, well, they already breached the contract, so I can't have breached it, that one doesn't. But for the rest, it's probably safest. And what we counsel our clients now is file a defensive claim.
And is there any issue on the timing of when you need to certify that claim? I don't, with regard to the timing of the default termination, filing the REA or the certified claim before the default termination or after?
So if you can, you want to do it before, right? If the termination for default comes too quickly and you don't have time, then you can do it immediately thereafter, but you want to make sure that there's enough time for the contracting officer to deny that claim, or at least for there to have been deemed denial before you have to appeal it.
Great, thank you.
It seems as much as we have want to have a simplified process for resolving claims, we keep finding ways to make it more and more complicated, more jurisdictional ways. Is that your reaction to that case?
That's my reaction to this case and others in the area. There does seem to be a more direct impact, or at least a pathway to get rid of cases by not saying there's jurisdiction or dismissing them for all sorts of other reasons that really don't get to the merits. So there does seem to be that kind of a trend in the cases. At least that's where the government is running. So, and the boards and courts are often following them.
But as we'll see a little bit later, it works both ways.
It does. So, in probably my favorite case of the year, the North American Landscape Construction and Dredge Company case, and a favorite case not because anything great happened to any of the parties, probably just the opposite, but it's an odd contract. It was just a dredging contract for the Scarborough River, and I'll call North American Landscape NALCO. So they filed a claim seeking the unpaid balance of their contract plus some additional costs. And what the case really started, interestingly, it is a claim, but it started with a bid protest process. And in fact, the board was very interested in what the government had done during the bid protest. So NALCO was originally the awardee under a sealed bid. So it had a low price, and it had an extremely low price, so low that the contracting officer went to them and asked them to confirm that their bid was correct. They did. A protest followed by one of the other offerors, and at that time, the contracting officer looked at NALCO's bid and said, oh, wait a minute, you proposed this smaller dredging machine, which you own, small business, but that's not big enough. That doesn't meet the requirements. So you have to give us a larger dredging machine, one, of course, in which you have to rent. So, and the contracting officer gave NALCO a take it or leave it approach, which was give me the larger dredge machine, but I'm not going to allow you to increase your bid, knowing that there was still a big difference between theirs and the other. And NALCO agreed. But they had, in CLIN 1, their mobilization base, they figured enough money to keep them going. So in order to defend itself in the whole protest process, the contracting officer then went back to the independent government estimate and changed it to reduce it so it looked closer to NALCO's price. And the protest concerned whether the bid was materially unbalanced, because there was a big piece in the mobilization base cost and then lower costs for the rest. And the contracting officer agreed that it was material, but they said it's not mathematically because there's no way the government will pay more. So the first thing the board then looked at that and said, well, this was a sealed bid. You didn't have the right contracting officer to tell them to change their bid. And it wasn't a mistake, it was just wrong. So you probably shouldn't have given them the contract in the first place. But having given them the contract, now you've created a problem for a small business. And it's unusual in claims to see the board actually address something that happened during a bid protest, but they did. But they found that telling them that they had to absorb these other additional costs was just totally improper, and they created a cash flow problem. But they didn't. The agency didn't, as a Corps of Engineers, didn't just create a normal cash flow program. What the agency then did to the contractor is they said, well, we're not going to pay you your CLIN 1 costs up front. We're only going to give you a very small portion. They're supposed to pay 60% normally, but there's a DFAR clause, 252, 236, 7004, that can limit mobilization costs. And they decided, the contracting officer decided they're going to invoke that provision. And as a small business, you've now imposed additional costs to rent equipment, and now you're not going to pay them the costs so that they can't actually pay for any of this. And in doing this, the contracting officer, the excuse for invoking this clause is, well, if I pay them up front, then they won't do the work. And the board said, well, how could you award a contract to a company who you don't believe would actually perform the work if you don't pay them in accordance with the way you've told them you were going to pay them? And the contracting officer's assertion, which is terrific, is it is not the practice of the U.S. Army Corps of Engineers to counsel contractors on their cash flow concerns or provide financing to contractors who experience cash flow problems. The board found, in some of my favorite language in the case, that the contracting officer's actions show a degree of callousness unexpected from the government, since the government caused NASHCO's cash flow crisis. And in fact, they said that the board found that the contracting officer abused her discretion in invoking this clause because she knew it was going to cause a cash flow crisis, and there was no rational basis to actually invoke it. And that was part of the decision that the board used in relying to determine that, in fact, the contracting agency did not act in good faith and did not treat the contractor fairly. So this is a good faith and fair dealing case. Now, it used to be that in order to win a good faith and fair dealing case, you had to prove that the government's actions were specifically targeted against the contractor and that they reappropriated benefit guaranteed by the conduct that had been guaranteed by the contract to the contractor. But the board jettisoned that in favor of the decision from the Federal Circuit in Syntax, which now says you have what the duty really is not to interfere with the other party's performance and not to act so as to destroy the reasonable expectations of the other party regarding the fruits of the contract. Now you can see that this makes sense here. Probably they would have satisfied either test, but here it was clear that the government was not acting in good faith and fair dealing. And in fact, the board said it can't ignore what it referred to as a disturbing attitude toward NALCO by the government. And it found that the agency officials had joked about how the fact they were going to have to babysit this contractor because they were limiting its funds, and it had been informed by NALCO very specifically that it was going to go bankrupt if they didn't pay the mobilization funds, and they said, well, that's their problem, it's not ours. And if this wasn't enough against this poor contractor, the government also did something else. So immediately after award, so it's a dredging contract, you got to pull this stuff up and you have to put it on land. And what they found is immediately after award, the Corps told the parties, oh, by the way, we're building this revetment, which is a barricade, right where NALCO was going to be putting the stuff that it was dredging. NALCO asked them, don't do it now, can't you wait until I'm done? And they said no. So they continued to do it and claimed that he was entitled to no additional funds to do this work. And then, because that wasn't enough, NALCO was then delayed in performing because it had to move the stuff elsewhere, not at a property that had, during the site visit, said, okay, that's where we're going to move it, what any contractor would have done. So it was delayed, and so what did the contracting officer do? They threatened to terminate NALCO for default. So then the question became, well, was that threat even reasonable? And the board said no. And in fact, the contracting officer wrote a letter to NALCO in telling it that it was going to terminate it for default, which one might view as a lack of self-awareness on the part of the government, where it said, the goal of the Corps in this matter was to provide you with the resources necessary to complete the project while limiting the risk to the government. Further, that they were committed to partnering with our small business community to meet our mission requirements, and that they also took extra measures to limit financial damage to the company. And the board very aptly said nothing could be further from the truth. That the government clearly didn't partner with them. They actually acted to damage the contractor financially. And in fact, the sad part of it is that the individual, the small business owner, lost his home, equipment, and business as a result of the government's actions here. The board said that when presented with evidence of the validity of NALCO's claims, government senior management, failed to act to remedy the problems. These examples are not merely anecdotal. At every point where an important decision had to be made, the agency chose to protect itself rather than act to successfully complete the contract or redress NALCO's legitimate claims. Then to top it all off, because it wasn't enough that they were going to threaten to terminate them for default, they then said, okay, we won't terminate you for default, but we're going to enter into a modification. And I know you said we owe you over $1 million, but here's a take it or leave it. We either terminate you for default and we get the surety to pay the bond, or we terminate you for default and we take everything, or you can sign this modification with a complete release and we'll give you $375,000. So not unexpectedly, NALCO said, well, I'm going to at least try to save my house and business, and so he signed the release and the mod. But he testified he felt he had no choice, which clearly he did not. And so what the board found was that the contracting officer first violated the express provision of the contract, the default clause. And that, in fact, they said, without a good faith belief that the action was permissible under the contract, he threatened to terminate him, when clearly there was he had a right to an excusable delay. And therefore, the board found that the signing of the modification with the release was unenforceable as a result of duress, which doesn't happen very often in government contracting.
That's tremendous.
And so threw the release out.
You know, I started my career at the Corps of Engineers in the 90s on active duty when partnering was all the rage. And the idea is, let's avoid litigation, let's make sure our projects get done. This seems to have been perhaps a lesson for getting back to that.
It definitely seems to be that. It was pretty remarkable, and I commend the case to folks reading it. It is pretty amazing to hear how many shenanigans the government, and I don't necessarily, I mean, the board did not find they acted in bad faith, they just found they didn't act in good faith, and they always took action that would hurt this contractor, and if you're going to have small business contractors, you have to act in good faith, right? You not necessarily go to an extreme where you're hurting the government, but you need to protect both parties.
Yeah, that's a great case.
Yeah.
Thank you for that.
Sure.
So I'm going to go next, and thank you, I'll take that.
Oh, yours?
I'm going to start talking about the Unified Liquid Gas versus United Pacific Energy case. This was a case where GSA entered into a scheduled contract with a contractor that provided propane gas for multiple agencies. And this started in 2002. The contractor started providing gas under task orders. And around 2010, not around, but actually in 2010, the GSA learned that UPE had not been charging the schedule prices that they had agreed to, and they took some corrective action. Following year, in 2011, Fort Irwin started placing task orders under the scheduled contract, and once again, UPE was billing, but not the correct amount. The government figures this out over the next couple of years and seeks to bring a claim for overpayments. And one thing they say is that in 2010, we knew that there had been these overpayments on other task orders, but in October 2011, we start to recognize the overpayments on the Fort Irwin task orders. And then time goes by, they continue to notice these discrepancies, but they wait to bring a claim. Finally, in March 2016, GSA issues a demand letter and says to UP, you owe us this money. And the GSA OIG comes into play, confirms all of this, and in June 2017, GSA issues a final decision adopting the OIG's findings and demanding repayment of the overpayments. There's no dispute about the overpayments, but time goes by. By the time this gets to the board, UPE is arguing, well, you waited too long. You had everything that you needed to know in January 2011 when you started paying these invoices for the claims to accrue. And interestingly, UPE made this argument based on the 2010 report showing the overpayments on other task orders, but that's not what the board seized upon. The board looked to the fact that Fort Irwin and GSA received these invoices, and each invoice contained unit prices and quantities, and the unit prices were wrong. And therefore, they knew or should have known that the claims accrued the day that they started signing these invoices. And so they win. The contractor escapes liability for these overpayments. In reaching this decision, the board looked to the Federal Circuit's 2016 decision in Kellogg, Brown, and Root at 823 F. 3rd 622 to say that the early 2011 claims were barred. And they looked at the FAR definition of 33201 as well for when a claim's accrued. the date when all events that fix the alleged liability on either the government or the contractor and permit the assertion of the claim were known or should have known. Since these invoices were for a sum certain and it was verifiable, there's no looking behind them. You can line up your invoices directly with the contract. They said, too late, you should have known. It's interesting, and it obviously cuts both ways, because contractors as well, if they're underpaid, are going to run into this same issue. This issue of a sum certain being easily, readily verifiable, I think is very important, a very important distinction. One thing that the court did not go into very much is the fact that UPE's argument that GSA knew in 2010 that they were mischarging.
Right.
It's a creative argument. You knew long before that I was doing it wrong, therefore you should have said something. And similarly, not important was the fact that in late 2011, 2015, the government comes to this realization. So it's not the date of the realization, it's the date that they should have realized based on this sum certain. So this is an interesting case that I can imagine coming up frequently over the coming years. The next case I'm going to talk about is the ACI case. This case is a bit of an odd case that is not likely to come up again, but it's worth mentioning for a reason I'll get to at the end of this. Between 2008 and 2016, the government awarded construction contracts to a JV in Afghanistan. The JV subcontracted to a company in Afghanistan. That company was called R1 Road and Construction Company. The CO ended up in 2012 terminating the prime contract with the JV. The JV appealed to the board, and they ended up settling the case, getting full releases in February 2016. Well, the subcontractor then learned in May 2016 that its claims to the prime had not been included in the settlement, and it sues the prime in state court and seeks contract damages, and it wins. Meanwhile, the JV is in bad financial shape, and R1 wins the right in state court to act as a trustee for the JV. So R1 goes back to the board and says, we want to reopen this. And the board says, no, it's already settled. You have no right to reopen it. The subcontractor R1 then goes to the Court of Federal Claims seeking to do the same thing, and the judge essentially reached the same conclusion. You've already lost the rights. This thing was closed. Even though you're standing in the shoes of the company as the trustee, it's already resolved. But the more important issue is the reason for, the other reason for dismissal. And that is that the court found, since R1 had already tried these arguments at the board, they could not reassert the same arguments at the Court of Federal Claims under the election doctrine. And so we talk about having two bites at the apple, especially in the bid protest context, right? Mm-hmm. You can go to GAO, you don't like the answer, you go to court. Well, this was an interesting ruling in that it essentially said, you don't have two bites at this apple. So I think that's going to be of limited value, but it's still an interesting result worth mentioning today. Okay. I think next we're going to turn to Judge Summers.
Oh, okay. Great. So I have two cases. Thank you. I don't know how to use this.
Just right and left.
Okay, got it. Okay, so Meridian Engineering Company versus United States and Secure Force International. So I'll quickly go through Meridian because I think Secure Force is the more interesting because there's a follow-on case that I wanted to kind of talk about. So Meridian, basically, I'm putting my glasses on, involved a contract at Chula Vista Project to construct flood control structures. And they encountered a lot of problems. First, they thought it was going to be, it's always differing sites. So first they thought it's going to be hard clay material. Turns out it's very watery. They keep trying to do different change and modifications so that they could address those problems. Ultimately, the government suspended work because there's no way they could actually address the problems. And so the project was terminated in 2009, and the government disagreed as to how much was owed to Meridian. So they filed in Court of Federal Claims for breach of contract, breach of duty of good faith and fair dealing, and a violation of the CDA. The interesting thing is that the Court of Federal Claims denied the claim based upon accord and satisfaction. It went to the Federal Circuit. The Federal Circuit found that the Court of Federal Claims had not evaluated the facts to talk about the meeting of the mind for the modifications. So I think the interesting thing about that is that it skips the plain language in the modifications that included release language and says, go back to the court and actually look at the facts underlying the modification. I think that's an unusual result in that circumstance.
It definitely is.
Yeah, I mean, we don't usually see the Federal Circuit saying to go and look at extrinsic evidence. And if you compare it with other cases like Bell BCI Company versus US 570 Fed 3rd 1337, the Federal Circuit said because the clause was not ambiguous, we don't look behind it. But here they find something different. So I thought that was interesting. Secure Force International has been a case that we've talked about at a lot of different panels and forums. So, but it's worth going through it because there's been some follow-on cases since then. So Secure Force was a requirements contract to deliver fuel to 8 Iraq sites. After they awarded the contract, they realized that it would violate the Trade Agreements Act of 1979 at 2 of the sites. So, and they decided that getting a waiver would take too long. So they terminated those 2 sites for convenience. Secure Force is to deliver at these other sites, 6 sites, and they said they weren't going to be able to meet the deadline for deliverables. Then they only delivered small portions of it. So the government first went to other contractors to fill in the void and ultimately ended up terminating the contract for default based upon their failure to meet those goals. So Secure Force filed in the Court of Federal Claims, alleging the T4D was improper. Then it submitted a non-monetary claim to the contracting officer, requesting a termination that the earlier T4C was improper and a breach. The contracting officer refused to work on that, to make a termination on the non-monetary claim because it did not seek damages in a sum certain. So Secure Force amended the complaint before the Court of Federal Claims, seeking to find that the T4C was improper. Court of Federal Claims claimed jurisdiction over both counts, and on the merits held that the T4C was improper and a breach, but rejected the prior breach as a defense. And so it goes to the Federal Circuit. The Federal Circuit basically says that the fact is that one of the arguments that Secure Force was making was that the contracting officer didn't actually make the decision. And the Federal Circuit said it was actually the government who made the decision. But the most important thing is really that they remanded it saying that the essence of the claim, even though they said it was non-monetary and was interpreting clauses, was that ultimately they're seeking money. So it is a monetary claim, and so they have to go and file the claim and get a certification. That has led to another case that was held at the board, the civilian board, Duke University versus Department of Health and Human Services. And the interesting part about that case, it's kind of in a weird posture. The parties wanted it to be dismissed for per agreement, and the board refused to dismiss it because they said there was no jurisdiction. And the reason why there was no jurisdiction was, once again, they did not include in their claim a request for a sum certain. They said they were looking for contract interpretation, but ultimately with that interpretation, they would get money. So it just makes you wonder, when can you have a non-monetary claim? Because always you're going to be ultimately looking for money. Unless it's while you're performing the contract and you need to have an interpretation so you can know how to determine performance. But ultimately, you're looking for money, right?
I think, and even if you're looking for performance, isn't it always about money? People aren't going to sue for the principle of the thing.
Right.
So at the end of the day, a logical conclusion of any decision is going to be some monetary impact.
Right.
So, I find these decisions very difficult. I can see a distinction, and I think the courts, boards try and give us objective standards so companies know. And I could see one, seems reasonable to me, that says, okay, if you're asking the board or the court to give you a certain amount of money,
Right.
then fair enough.
Right.
That's a monetary claim. But if what you're really seeking is, a cast determination or something that will logically, as its conclusion, have some monetary impact, but you're not asking
At
the
that
board
time.
or court to
Right.
give you a sum certain, that could be a later claim, then it shouldn't be a monetary. It seems an objective standard is what's called for here.
Yeah, it definitely seems like, I can't imagine what contractors are going to do when they read these cases, and they are dealing with issues in the middle of performance where they really just need interpretation, because it could easily be turned into, again, the monetary claim. That interpretation may cost them money, and so then they're going to seek a claim. If it doesn't cost them money, well, maybe we don't have a problem then, but typically the questions aren't asked because they're looking for nothing, right? So,
Right.
yeah.
Interesting. Good case. All right, thank you. Finally, let's turn to our friend Craig Holman, who's got one of my favorite cases of the year.
Yes.
The
I love that
KCON
case.
case. It's a great case. We could chew on this one for an hour alone.
Sure. I mean, we could fill this whole panel with it, and I think Robert just called it his favorite case of the year. I was going to say, to me, this may be the most unfortunate case of the year. We'll get into this in a little more gritty detail here in a second, but at bottom, this case, as many folks in the area know now, is a Christian doctrine case. The Christian doctrine's been around for a lot of years. 50 plus years at this point, and deals with the reading into contracts by operation of law of contract clauses. And so it is a bit odd for me to say that this is arguably the most unfortunate case of the year when we're dealing with a doctrine that's been around for 5 decades. But as we'll talk about here today, I think KCON has actually changed and expanded the application of the Christian doctrine. And it's done so in a way that I think is unhelpful for both the government and contractors, because at the end of the day, contracting is about certainty. Uncertainty in contracting for the government brings higher prices. Uncertainty in contracting for contractors may cause them to bid higher prices or may cause them not to bid at all. And neither of those outcomes is good for the contracting community. And really, the Christian doctrine at its essence, although it does serve some important functions, is really breaks from a traditional sense of parties being able to sit down across from each other and put down in writing what their actual intentions are. And the Christian doctrine is a break from that. I'm going to spend just a few minutes on the facts, and then we'll talk about the key holdings in the case and why I think it's so problematic, and hopefully we'll get some dialogue on this because it is such a significant case. It's a short one, by the way, folks, so you can pick this up and read it very, very quickly.
Well, you should also read the underlying board decision, which
I
I
agree.
think is very well reasoned.
And also short. In September 2013, the Army issued 2 solicitations through GSA eBuy covering design and construction, and this is important, of prefabricated buildings for use at Camp Edwards, Massachusetts. One called for delivery of a laundry building, one called for delivery of a communications building. First of all, both solicitations went out under an SF 1449 for commercial items. Neither solicitation included FAR 52-22815, which covers performance and payment bonds for construction contracts, notwithstanding that the description of the contract did include some language suggestive of construction. October 2013, Army selects KCON to provide the work, and after doing so decides that it needs the performance and payment bonds. Over a course of 2 years, the next 2 years, they go back and forth on this issue, and ultimately KCON provides the performance and payment bonds in September of 2015, 2 years after award, and gets a notice to proceed. Interestingly, the government modifies the contract and pays for the performance and payment bonds. A few months later, KCON, now facing a different labor market and increased costs, puts in a request for equitable adjustment for costs, which the contracting officer promptly denies using the Christian doctrine, saying that clause was read in by operation of law and the government ought to have no liability for those increased costs. A CDA claim followed. which was denied. It goes to the Armed Services Board of Contract Appeals. The Armed Services Board of Contract Appeals also applies the Christian doctrine and says 52228-15 was read in by operation of law, and therefore there is no recovery for these increased costs. KCON appeals to the U.S. Court of Appeals for the Federal Circuit. And to me, here's where things really start going off the rails. At the Federal Circuit, the United States makes a patent ambiguity argument that to me is the game changer in this Christian doctrine case. So let's drill down on the holdings in the case now that we have some of the background, and we can talk about what the two subholdings are after we get to the first top-level key holding. The top-level key holding is the Christian doctrine incorporated performance and payment requirements by operation of law into two commercial item contracts for pre-engineered metal buildings. That's at bottom what the Federal Circuit did. The first subholding, and this is what really to me has been vexing as I've read this case over and over, trying to figure out what was happening and why this case really has a sense when you read it that it's wrong, that the outcome is wrong. And it's ultimately for me, and there have been a number of articles on it, by the way, including one by Robert Steam. Ultimately for me, it's this patent ambiguity issue that drives that feeling for me. So the Federal Circuit hears this case, and KCON comes before it and says, hold on, this is not a construction contract at all. So you shouldn't be reading a construction contract clause in by operation of law. It's a commercial item contract. The United States says, Federal Circuit, you shouldn't consider that argument because the base contract and the solicitation both reference construction, and they had a Davis-Bacon Act clause. So even though it went out under a SF 1449 as a commercial item contract, it also had construction contract clauses. And the United States argued to the Federal Circuit that therefore KCON could not argue that this was a commercial item contract instead of a construction contract. And the Federal Circuit agreed. They said patent ambiguity, KCON could not argue that it was not a construction contract. The Federal Circuit, the key problem, by the way, of this holding for me is what it does in the context of the second step of the Christian doctrine. So in the second step of the Christian doctrine, the Federal Circuit reached a holding that I think was relatively unremarkable in the landscape of Christian cases, that performance and payment bonds, and particularly, from my perspective, that payment bonds protecting laborers represent a fundamental public policy. So that, since Amoroso did that with the Buy American Act back in the 1990s, that to me is less of a surprise. What was really a surprise to me about this case was that the court would not let KCON argue that it wasn't a construction contract at all, based on a patent ambiguity argument. And what this resulted in is the Federal Circuit reading into a contract by operation of law, something that it declared to be a significant public policy, even though that clause might not apply to the contract. And to me, that's a problem. That divorces the Christian doctrine from its moorings, which are, is this clause required in this contract, and is it so deeply ingrained in public policy that it must be there? And when the Federal Circuit allowed for patent ambiguity to take over whether or not that clause was actually required, the case became troubling to me.
It's such a troubling case on a number of respects. The first one that caught my eye was this question, can a construction contract be a commercial item contract? And the board seems to say, perhaps it can, and that does not determine anything. But, there have been different opinions on this over the years. I think in 2001 or 2002, OFPP came out with a memo saying that construction can be commercial item, but generally shouldn't be commercial item. Well, what does that mean, right? And there's this vagueness around whether construction can be, and it's really up to, I think, contracting officers in the absence of better guidance to make this determination. I did a case back in 2004 where a client was asked to build a power plant in Baghdad for the U.S. government. And the client said, we are not taking on U.S. government contracting. And the agency said, well, what if we do this commercial item? And we talked it through. Well, how is this a commercial item? Well, a power plant is turbines, right? We're buying the turbines and all the construction to install them. And in that instance, the government decided we both want it to be construction and commercial item, and we're going to decide what clauses go in, and you can rely on it. So this threshold question that the Federal Circuit went to, that it has to be one or the other, I think doesn't make sense.
I think it doesn't make sense for, and we could spend a lot of time on this case. It doesn't make sense for a lot of reasons, but you could ask even, I'm sure we have many folks who do commercial construction work and government construction work watching today. And there's a question at its bottom. I mean, of course, a payment bond is designed to replace a mechanic's lien, right? These are prefabricated buildings. I don't even know that it's resolved at the state level whether a prefabricated building is subject to a mechanic's lien.
Or whether it's even construction versus installation of a commercial item.
Of course. And then you get to the point that FAR Part 12, although it does contemplate a commercial item contract, will have particular clauses, also gives a contracting officer latitude to diverge somewhat, to add other clauses that might have relevance, as you know, to make difficult decisions. And ultimately what the Federal Circuit was saying was that this small government contractor should have been policing the federal government and the federal government's contracting experts to make sure they weren't making mistakes. And when the federal government contracts experts made a mistake, the small business got held liable for it. And that to me is really, this to me, just particularly when they rolled the patent ambiguity into this, left me with a bad feeling.
And not just liable for performance with a requirement that they didn't sign up to, but liable for any costs. Now this was interesting. The government paid for the bonds, but didn't pay for the delays, right?
Oddity.
It's completely odd.
Incongruity.
Yeah, it's internally inconsistent. And you're right, in a commercial contract, they can include all sorts of clauses that aren't in, but they have the right to do that, and having failed to have done so, how can then you just convert the contract and then everyone, so in any commercial contract, you could have that same problem. It doesn't have to just be construction. It can be any contract.
And how does this jive with the Section 809 panel saying we need to be doing more commercial item contracting and we need to be looking at commercial market terms? I mean, when you're a commercial company and you get an RFP and you bid on it and the government says, well actually, in the Army's defense, it wasn't the Army at the board that made this argument. Once DOJ took it over, they said, oh, you know, it can't be both, and it has to be one or the other. You read it in. You know, why would you, as a commercial item contractor, trust that you're not signing up for something you didn't bargain for?
Well, it's interesting too because the Federal Circuit in another case, which is not on the slides, but Rockies Express Pipeline versus Salazar, which is in 2013. I'm going to read some language that's directly contrary to what they're telling us now. So it says, finally, the board observed that Rockies Express does not have a history of contracting with the government. Thus, it was presumably unaware of whether a particular FAR provision is applicable. I mean, the whole thing was turning on whether or not the FAR provision is applied. And now we're hearing that not only do they not need to know, but we're just going to assume that they should know. And now you have a small contractor. The Rockies Express was a giant contractor, billions of dollars contract. But they get the benefit of the doubt. It's just an interesting kind of turn of events.
It's an oddity, and when we put our slides in, I actually was recalled to Nash and Sabinic Reporter article a few years ago where they were doing an overview in the mid-1990s after Amoroso about the Christian doctrine, and they drew the conclusion, we can't remember an instance after reading all of these cases where we read more and learned less. It is clear that you can't tell a significant and deeply ingrained strand of public policy, prong 2 under this Christian doctrine test, when you see it. And we put these slides together. I didn't realize that there was going to be, Professor Nash was going to put an article out last week about this case, but he actually did. And you know, I was drawn by this quote, and I said, look, this even expands it because now prong 1 is dealt with as a patent ambiguity. Prong 2 is uncertain. How do contractors deal with this? And Professor Nash wrote last week that essentially the sentiment of his article was that if you're a small contractor, you really have to think about doing business with the government. If this is how your business partner is going to treat you, that they're going to hold you financially responsible for their mistakes. And that's really, to me, what was disappointing about KCON. We've got a couple other things that...
And we do have a question from the audience, and this is open for anybody. Are there any myths that the panel can debunk about the claims process? Go right ahead.
I would tell you, I mean, one myth that I think we've heard today, and if we get to a couple of these other cases, we'll see, is that it's a simple process. I think, unfortunately, although Congress, when it passed the Contract Disputes Act in 1978, envisioned a simple process, as a result of all of the jurisdictional litigation, and we've seen decades of it on issues, and it comes and goes in waves, but it's just not simple. In that it's not simple for contractors to do without lawyers, and sometimes it's not simple for lawyers to do.
You know, this KCON case, I called Bob Simon, who litigated it on behalf of KCON, and he took it to the Federal Circuit because he really believed that the board decision was wrong. He took it pro bono to try to correct a bad decision.
Didn't work.
Well, we have a couple.
No.
Yeah,
Okay.
go right ahead.
I have a couple other slides. We only have a couple minutes here. I'm not going to spend long on the CB&I case. This is a Court of Federal Claims decision that I commend to folks. It's a relatively short decision by Judge Wheeler. What I liked about it for folks who are reading in the area was that it has a number of key interesting topics, some of which we've talked about here today. That I'm not going to go through because of the shortage of time, but there are three in the slides that you can see. There's another two in the case. It's a really interesting case about a contract that's been going since 1999, if you can imagine that, a contract that started in 1999 for a mixed oxide facility contract that now is set to be completed. The facility is set to be built in, I think, 2028. So it is quite an interesting contract, quite an interesting case. I'm not going to spend a lot of time because we're running out of time here today. I do want to touch on the first point because it ties back to what Ann was talking about earlier today. One of the issues that came up in the case, the contractor had filed a $50 million claim against the government for failure to pay incentive fees. And when the government got that claim, it not only denied the claim, but it attempted to claw back $21 million in provisional incentive fees it had paid. So not only did the government deny the claim, it then went back in its final decision and clawed back $21 million in provisional incentive fee payments. And when that hit the court, one of the questions was there a contractual basis to do this? What clause was the government using to claw back these incentive fees when the contract talked about something that this resolution of incentive fee issues happening in a particular way? And the bottom line is the government couldn't find it. And Judge Wheeler, looking at the case, I think believed that they had used the claims process as a tool to leverage their negotiating position against the contractor. And the question came up, much like in the case Ann was talking about earlier, is the government subject to a requirement of good faith in making a claim? We all know contractors are subject to it. Contractors have to certify their claims that they're making them in good faith, over $100,000. And in all events are subject to the False Claims Act. So the reality of the matter here is that the court looked at this particular issue and concluded that indeed the United States itself is subject to a reciprocal obligation to act in good faith when it makes a claim. An important fact for contractors to remember.
That's true.
And the government to remember.
Well, I personally would like to see the ability to get the award of legal costs in cases like that, but we'll save that for another day. This panel has gone really well. I want to tell you as we close up, PubK in January is starting a podcast once a week, and we will be sitting around debating these types of cases and hopefully, just like we did today, interject a little bit of humor in them. So we have Kevin Mullen, who will be a big part of that, because as you know, he's the funniest lawyer in government contracts. And we'll be covering a broad range of topics. But I want to thank you for this today. Judge Summers' excellent analysis. And Ann and Craig, thank you for the time put in on this, and thank you for tuning in today. The next panel will be in 10 minutes on intellectual property, information technology, and cybersecurity at 11 o'clock. Thank you.